This is Kip from Malik & Malik. Today I'm going to be talking about a case involving permanent total disability. So in the workers' comp world, what ends up happening is when you get a work injury, there's three different paths that you go down. You get injured, you file your claim gets allowed or gets disallowed, and then you settle. You file your claim gets allowed, and eventually you're not able to go back to work and you file for PTD. And then the other option is you file your claim, you can continue treating, you don't treat for a while, and then your claim basically dies because you haven't continued treating. So those are kind of the three paths that your workers' comp claim can go down. And all those paths take a while to get to those points. But this case is a full commission hearing case, and I've talked about in the past, full commission hearings are you go to the DHO, SHO, and then you can file a third level appeal, and then alternatively you can file a request for reconsideration by the three commissioners. So that's what this is. And what had been happening is it looks like at the SHO, the SHO hearing officer granted PTD for this claimant, and then the employer or the employer or the BWC filed an appeal or a request for recon, and the request for recon was granted because what they're alleging, the reason why is because there's a mistake of fact or law, because the doctor who the SHO was relying upon to grant PTD did not consider the non-allowed conditions. So they did not consider the PTD absent of the other conditions which weren't allowed in the claim. So they kind of created an opening for this thing to go before the full commission. And then what the full commission ended up doing is, with PTD, you could be found medically PTD, and then the hearing officer doesn't go into the vocational factors. But if you're not found medically PTD, then the hearing officer will go into the vocational factors, and then they may or may not allow PTD based upon that. And so what happened in this instance is there was three different doctors. I think there was a physical medicine and rehab doctor evaluating the vocational ability of the injured worker, and that doctor concluded that this individual would have been able to do light physical demand type work. Another doctor for the commission found that the injured worker was capable of sedentary work, and then a third doctor, again, same thing, the injured worker would not be able to go to the job that the former position of employment, but they would be able to do kind of light physical demand type work. So again, kind of sedentary type work, etc. So what that means is they're not medically PTD. So the commission's going to look at the vocational factors. So what they end up doing is this guy was 63, and so you would think 63, that's getting near retirement age, but in terms of the Industrial Commission and PTD, 63 is young. And so they said, well, age is not a barrier to employment, and they looked at it as a neutral factor, and so they're saying, hey, other people that age are able to get work. So kind of, SO on that point. And then they look at other things. So they look at this individual's prior education. So he had a GED. They considered a person with a GED, they have the ability to learn. So that's a plus factor for the ability to get back into the workforce. They looked at it as a plus vocational factor. They looked at the fact that he was he served as a supervisor or manager at one of his prior jobs, and they said that was another plus factor. Because leadership, it kind of entails that you're able to manage people and you're able to manage yourself, etc. And so they're looking at all these things, and his GED, his prior experience as a manager, his ability to get different jobs and be able to adapt to these different jobs, and they said, hey, this guy can go back. He's capable of working at least in a sedentary type job, and therefore we're going to deny PTD. And the weird thing is, if you look at all the jobs that this guy had, they're all kind of delivery driver type jobs, and I'm assuming it would probably be very difficult at the age of 63 or 64 or 65 to completely re-immerse yourself into an entirely different career. But that's the way that the Industrial Commission looks at these things. So PTD is a harder. It's you have to be unable to do sustained remunerative employment, and if you can, then they're going to deny it. It's a little bit more. You could be found disabled per Social Security disability, but not be found permanently totally disabled via the Industrial Commission. So it's a tough. It can be tough standard to breach. And again, I went from one completely disparate career path, game development, to law, and you would say, well, you have a college degree or multiple college degrees, and I found it hard, and I was younger, I was 30 something, so I'm 30, this guy's 63. It's just, I'd imagine it's just a very, very hard thing to overcome. But again, that's what the Industrial Commission, that's how they're looking at these things if you're not found medically PTD. So anyways, that was a case involving somebody who applied for PTD and their PTD was denied by the Industrial Commission. You've been listening to Kip from Malik and Malik. If you have any other questions, comments, concerns about this case or any other case, please by all means leave questions, comments below. Alternatively, give me an email, give me a call to my office. Workers' comp in Ohio is a difficult beast, so don't do this stuff on your own. All right, that's kind of the big lesson, that if there's any lesson that I can impart from you, it would be that. All right, thanks for listening.